ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್, ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದ್ದೀರಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಮೇಡಮ್ ಮೇಡಮ್ ನಿನ್ನೆ ಲಿಸ್ಟ್ 3 ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಏನಾಯ್ತು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್. ಅದು ನೆಟ್ವರ್ಕ್ ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು, ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ಒಂದು ಹೇಳ್ತೀರಾ?
ಇದೆಯಲ್ಲ ಕೇಸ್ ಚೆಕಿಂಗ್ ಆಪ್ಷನ್ ಇದೆಯಲ್ಲ, ನೀವು ಅಲ್ಲೋಗಿ ಚೆಕ್ ಮಾಡ್ಕೋಬೇಕಲ್ವಾ?
ಅಪ್ಡೇಟ್ ಆಗ್ಲಿಲ್ಲ ಮೇಡಮ್. ಅಲ್ಲಿ ಆಗ್ತಿದ್ರೆ ನಿಮ್ಮ ಹತ್ರ ಕೇಳೋದಿಲ್ಲ. ಇದೊಂದು ಹೇಳಿಬಿಡಿ ಪ್ಲೀಸ್.
ಅಪ್ಡೇಟ್ ಆಗಿರುತ್ತೆ ಸರ್, ಡೇಟ್ ನೆಕ್ಸ್ಟ್.
ಇಲ್ಲ ಮೇಡಮ್, ಆಗ್ಲಿಲ್ಲ ಖಂಡಿತವಾಗಿ. ಇಲ್ದಿರ ನಿಮ್ಮ ಹತ್ರ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಸುಳ್ಳು ಹೇಳಿಕೆ? ಒಂದು ಹೇಳ್ತೀರಾ? ಅವರು ಏನೋ ಅಫಿಡವಿಟ್ ಏನೋ ಹಾಕಿದ್ರು, ಅಷ್ಟು ಗೊತ್ತಾಯ್ತು ಮೇಡಮ್. ಹೌದು ಮೇಡಮ್, ಹೌದು. 247 RPFC.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಹಂಗೆ ಲೈನಲ್ಲಿ.
ಆಯ್ತಾಯ್ತು.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಸರ್.
ಹೌದಾ, ಸರಿ. ಹೌದಾ, ಸರಿ ಆಯ್ತು. ಸರಿ ಮೇಡಮ್, ತುಂಬಾ ಥ್ಯಾಂಕ್ಸ್, ತುಂಬಾ ಥ್ಯಾಂಕ್ಸ್.
Lord, Lord, may I make one submission, my Lord. Lord, this matter pertains to MVC, my Lord. Lord, that the victim petitioner has filed an application before the MEACT Ramnagar, my Lord, for the compensation. That was allowed, my Lord. So, stating that the respondent number 1 and 2 is jointly and severally liable to pay the compensation to the victim, my Lord. Thereafter, that the insurance company, my Lord, they filed an MFA before this honorable court, suppressing the valid insurance policy, my Lord. And this court has allowed that application, my Lord, for which I have filed a review petition, my Lord.
Where were you when the matter was heard?
My Lord, the notice was not served, my Lord, in that point of time.
Without serving the notice, why will the matter be heard by the court? Verify. List it in the
My
next
Lord,
week.
the urgency is that, my Lord, they have filed an execution petition in which that the warrant has been issued, my Lord.
We will see. Whenever the claimant comes to the court, that's the day. You are the owner of the vehicle? Or
Yes, my Lord. I am the owner of the vehicle, my Lord.
Yes. Owner of the vehicle will not represent either before the lower court or before this.
No, my Lord. I have appeared before the lower court, my Lord.
But here you are not appeared.
Here I have, my Lord, that I have not received the notice, my Lord, from this honorable court.
Yes.
My Lord, there is some urgency, my Lord.
Urgent.
Yes.
We'll hear it next week.
Yes, my Lord.
Convenience of the court.
Grateful.
Yes.
Lordships, kindly could I move a fresh matter for 2:30 today?
Why?
The urgency is this. The order is passed day before yesterday, released yesterday. I filed a petition. Father's petition challenging the interim custody of the child granted to the mother. The child tells before the court that she does not wish to join the custody of the mother. The trial court order notes that in the order also. Child also says that the mother in the previous time has assaulted the child by slapping her. All of that is noted in the order sheet. And yet the trial court says in the interest of the child.
No urgency at all. It will come on Monday.
The order is tomorrow, minutes. The interim custody is directed to be given, handed over tomorrow. The petition itself would become infructuous, minutes. Therefore,
because even if you move the application,
Yes.
this court will not pass any orders without notice to the respondent in custody matters.
Yes, my lord.
So
I
even
would at
that
least
way also, I will not
I would
pass
at
any
least make a
interim order.
request tomorrow that the matter will be heard. Therefore, it may be deferred, my lord. That's my only request. I'll make an attempt at 2:30, my
It is
lord.
not such an important matter that we have to take it up. Let it come on Monday. Yes.
My lord, kindly, my lord, this is sufficient with respect to RPFC matter, where my lord, earlier the husband has challenged this
Which year is the RPFC? So much of
2024
introduction is not required.
2024, madam.
Give
My lord,
it to the court officer.
interim order for payment of maintenance has been violated. I filed a necessary application
We will take up the matter.
next week, my lord.
We will see.
Next week, my lord.
Yes.
Because now he has filed a divorce petition in the Mysore court, my lord.
2025, you realize now to move
No,
the
my lord.
matter.
Interim order has been violated, madam. He's not paying maintenance,
But
my
I'm
lord.
saying after 1 year, you have realized.
No, my lord. The order has been passed subsequently, my lord, in the 15 months.
See, we will see
Grateful.
no urgency at the fag end of the vacation.
And next week, my lord, at least.
We will see. Yes, next.
Grateful.
Call the list.
My lords, the respondent is not paying maintenance to the petitioner, and hence there is a serious inconvenience, my lords. Matter may be
Which year is that?
My lords.
Which year is the petition?
My lord, this year, my lord.
2025.
2025. My lords.
Interim order is there?
Yes, my lords.
Huh?
The lower court's interim order is there, my lords. As far as my
How can, what is this? Just a week, now 2025 matter has to be heard finally now. We will see. There are so many matter next week. If the time permits, we will see. Take it.
Your Honor,
Yes.
serial number 19.
He will call page wise. Yes.
Your Honor, I am appearing party in person. I've complied with the scrutiny and Form C has been issued. So the relief sought is for non-adverse and procedural. So I request
The relief sought is?
for the speedy dispose of my matrimonial case pending in honorable.
Which year is that?
That is 2023, ma'am.
20?
23.
Let it come next week sometime, because anyhow, even if the matter is listed, I'm not going to pass any order.
It's just a memo for filing for listing for next
Let it
week.
come. That's why no urgency. List it
Okay.
someday. Wednesday, Thursday. Yes.
Page-wise adjournments, list number 1, serial number, page number 3, serial number 5 to 8, page number 4, serial number 9 to 10, page number 5, page number 6, 11 to 17, page number
19
7.
Swami. Serial number 19. Kindly have it on Monday to Swami.
Whom you are representing? You offer?
For petitioner Swami.
18 to 20.
Who is for the respondent?
Respondent will inform Swami.
Who will
Acharya.
inform? In this court, you have to inform and then mention or else wait till the matter is reached. Yes.
Page number 8.
Let's serial number 16, my lords. Serial number
Serial number
16.
16.
Joint affidavit was supposed to be filed. We have received the joint affidavit. The only technical issue is that the affidavit was not notarized in Hyderabad. The petitioner resides in Hyderabad.
Tuesday,
Wednesday, my lords, kindly
Yes,
please, sir, I
Wednesday.
can receive the. Grateful.
it is submitted that they'll come up with a joint memo. Yes.
Great.
Page number 7, cell number 18 to 22, page number 8, cell number 23, 24, page number 9, cell number 25 to 27, list number 2 for referring to local adalat matters,
Serial number 6, my lord. I'm for appellant.
1 minute, 1 minute.
page number, serial number 1, non-taking of steps to issue
Serial number
notice for
1.
R3 is
Filing memo for dispensation of driver of the vehicle.
Hmm.
R2 my lord was served in the connected matter.
R3 served here also.
Served, R3 served.
Can it be referred to the local adalat?
My lord, it's a permit issue, my lord.
Delete, delete, post in the usual course.
Serial number 2,
Two, I represent the appellant. I will furnish the PF and everything. A week's time, I kindly be there.
Yes, this also delete.
Please.
Remaining other matters refer to local adalat.
6, my lord.
Serial number 6, my lords. I'm for the second respondent.
Preparing for appellant in this case. Liability has fixed 20% as contributory negligence has taken.
Delete,
Look.
6 also delete.
in 5.1, memo for dispensation of notice
Wait.
to R2.
5.1, memo of is filed seeking dispensation of notice to R2. Memo is taken on record. Notice to R2 is dispensed with. Yes. Call the
List
list.
number 1, for dismissal matter, cell number 1, Rajesh A. for petitioner.
The appeal for respondent, my lord. The first matter is filed by the husband seeking reduction of the maintenance. And second matter is, my lord, wife petition seeking enhancement, my lord.
1 minute. Petitioner in, there is no representation on behalf of the petitioner in both the matters.
I am responding the first matter. Second matter, I am
I
petitioner.
said petitioner in both the matters, no representation.
Yes, my lord, doctorate of hearing.
Yes. Argue.
My lord, here, my lord.
You are
though-
for the wife.
Yes, my
You are
lord.
seeking enhancement.
Enhancement, my
What
lord.
is the amount granted by the court?
10,000 each to the mother and this the daughter, my lord.
That is 20,000.
20,000. Though the husband is a software engineer, earning 2.5 lakhs at the time of 2015.
It is there on record.
It is there on record, my lord. Not on record, my lord. Actually, my lord, he failed, though he is working as software engineer, he failed the assets and liabilities, my lord, saying that he has no income. Kindly see, my lord. Here,
Oh, where is the material to show that he is earning?
but there is no material produced by my
Then
lord.
how
No,
can
my
we?
lord, kindly see, my lord. Kindly see the evidence, my lord. Kindly see this. This wedding card, my lord.
Looking at the wedding card, you cannot say what is the income.
In wedding card, my lord, below his name, my lord, he stated that senior manager in Quest Global Engineering Limited, my lord, and also in
When was the marriage?
2013.
When is this petition?
This petition is 2020.
20.
At that
You
time,
cannot look at what is at 2013 and give an
no, my
order.
lord, he is software engineer. During the marriage itself, he is working as senior manager, my lord. He is earning more than 2.5 lakhs. Well, kindly see the assets and liabilities, my lord, where he stated that in saying that he made a false deposition, my lord. Kindly see, my lord. Kindly see, he filed a assets and liabilities.
How can I determine that?
My
How
lord,
can I determine that that is a false statement?
my lord.
I cannot.
Well, anyhow, my lord,
He
admittedly.
is not working according to him. Now, according to you, he is working. You have not filed, both of you filed statement of assets and
ma'am.
liabilities. If according to you, he has made any wrong statement before the court, initiate proceedings for perjury. So whatever is the evidence on record, basing on that only, we can pass an order.
That too, my lord, the trial court passed
10 and
meager
10,
amount,
20,000
my lord.
without any evidence
No,
is
meager
already on the higher side. Why should we interfere with that?
That meager amount, my lord. Meager amount, my lord. He is software engineer. That's my contention, my lord. He finally deposed before the
If that
court.
is the only contention, then I have to.
No, that is, my lord, that is only. And also, my lord, as per his verdict, he went to abroad, my lord, 3 times, my lord, to the England. It showed that his earning is well, my lord. Tell you, see, my lord, the pleadings, my lord.
Basing on your pleadings, we can't determine the maintenance. You should have made during the course of evidence, you
Well,
should
the
have
thing is,
made
my lord.
some effort to call for some information. Nothing you have done.
Well, now he changed his job, my lord. I don't know where he is working.
At least if he's working where he was working, if you know, at least you could have elicited something from that.
Well, that we tried, my lord, but ultimately, my lord,
We
by
cannot.
believing is
Because anyhow, the petition respondent is not there. We will not, the husband is not there. We will confirm this, but no question of announcement.
otherwise, my lord, have to
If the husband is,
let them present before
if the
court.
husband is there, I would have, this way, I mean, 100% reduce this amount. Yes, agreed with the orders passed in criminal miscellaneous number 589 of 2020, dated 4th January 2022, whereby the court had granted 10,000 each to the wife and the child. Both the husband and wife are before this court. Husband's petition is RPFC 172 of 2023, and the wife's petition is RPFC 18 of 2024 seeking enhancement. Though on the last occasion the matter came up, there was no representation on behalf of both the wife and the husband. As the matter is listed today under the caption for disposal. Today, then counsel for the wife is present, but today also there is no representation on behalf of the then counsel for the petitioner or the husband. The wife had filed the criminal miscellaneous seeking maintenance of an amount of rupees. How much is sought?
75,000.
5,000 per month to both the wife and the child. It is the case of the wife that the marriage has taken place on 13/11/2013 in Mysore.
One more submission, my lord. Here, my lord, though I led my evidence, they have not cross-examined. They have also not led their evidence, my lord, except filing version. So, my lord, my evidence has not been
In
impeached.
the wedlock, they were blessed with a female child. It is the case that when she was pregnant, the husband went abroad on 18/5/2014. It is stated that in the month of 2016, again the husband went abroad. In the month of 19, he went to London.
Kindly see paragraph 15, my lord.
It is a case of the wife that the husband is earning 2,50,000 per month, owning a two-storied house at prime area of Vijayanagara, Mysore, and also 8 acres of ancestral landed properties. The husband has filed his objection.
Paragraph 15, my lord.
No, I'll go to that para. Let me. He had denied all the allegations. It is stated that the wife is employed at Fine Arts Music College, Mysore, as a teacher and earning a handsome salary. And her father is also financially well planned, and she do not require any maintenance. The tribunal, by order impugned, had granted 10,000 each to the petitioner and the daughter, the wife and the daughter. While granting the said maintenance, the court had observed that The court, basing on the evidence, has come to the conclusion that the wife has no means to support herself. And courts also observed that according to the wife, the husband was working as a software engineer at Quest Global Services Private Limited and is getting handsome salary of an amount of ₹250,000. And also is having landed properties and also a two-storied building. The same were denied by the respondent. The court observed that though the wife had stated so many things, she has not produced any document to show that the husband is earning ₹250,000 from his avocation and is owning two-storied houses, 8 acres of ancestral landed property, 2 cars and 3 two-wheelers. But in the invitation, it is shown as wedding invitation, it is shown as is a BE mechanical graduate and is working as senior engineer at Quest Global Engineering Private Limited Company at Bangalore. The court, considering the qualification, has granted 10,000 each. Then counsel appearing for the wife submits that on behalf of the wife, she has examined herself as PW1 and on behalf of the on her behalf, exhibit P1 to P10 are marked. The husband has not entered into the witness box and entered into the witness box and he has not adduced any evidence. No documents are marked on his behalf. No documents are marked on his behalf. The learned counsel appearing for the wife submits that when the husband has not entered into the witness box, when she has adduced her evidence and she was not cross-examined, and adverse inference need to be drawn. And the court ought to have granted the maintenance as per the claim made by the wife. It is submitted that in the year 2013, when a person is working as a senior manager, now it is not open for him to say that he is not working. It is also submitted that she is not in a position to place any document before the court, as those documents are not in her possession. And even to cross-examine on all these aspects, he has not come before the court. In these circumstances, the court ought to have granted the maintenance as sought for by the wife. Next, no representation on behalf of the husband on the last occasion, that is on 28/8/2025 and also today. Hence, this court is proceeding with the matter basing on the evidence available on record. Next, having other counsel for the petitioner peruse the material on record. When it is the case of the wife that, as per the wedding card, the husband is working as a senior manager in Bangalore, and his income is 250,000. He, except filing the statement of assets and liabilities, showing that he has filed statement of assets and showing that he has no income. Neither he has cross-examined the petitioner, nor he has adduced any evidence in respect of, in support of his case. All these things clearly shows that there is an intention on the part of the husband to suppress the material facts. And whatever is evidence, whatever is the chief in examination in chief, whatever the wife has stated, that has to be considered by the court, as there is no cross-examination, or he got himself examined. And non-appearance of the husband even before this court on the last occasion and today shows that only with an intention to avoid payment of maintenance to the wife, he is not appearing before the courts. In that view of the matter, MFA RPFC number 172 of 2023 is dismissed, and RPFC number 18 of 2024 is allowed by granting compensation of an amount of rupees 75,000 to both the wife and the daughter. Yes, next.
For orders matter, cell number 2.
Respond. Claim. This case, not claim petition is dismissed. Claim petition is dismissed. The positions, Lord, all the criminal records are in Kannada. It will take, Lord, another 10 days to file it.
I didn't get you.
Or another 10 days to file, Lord, translation copies of Kannada.
Is there 10 days for filing?
Translation copies.
What translated copies?
Lord, the depositions and other documents are in Kannada. Since the claim petition is dismissed, therefore I want to, Lord, rely upon those documents. Lord.
You can read.
Lord.
There is a order sheet. I do not require any translated copies. I can understand if you read.
Yes, Lord.
Yes.
Lord,
My lord, kindly pass over, my lord. Senior on his leg.
This is matter after vacation.
Cell number 3.
At the request of one counsel for the respondent.
Cell number 3.
Yes.
C. Shankar Reddy.
My lord, appearing for petitioner, we have served the hand summons to the respondent.
There is a memo.
The memo. Yeah,
Take that.
seal also is there. In 14.8 only we have served the copy to the.
What is the name of the advocate?
Advocate name is Satya MN, madam. Satya MN. Here only sign is there.
So from the signature you are trying to read it. How can it be?
Sorry, madam.
Yesterday in your presence I said so.
Yes,
Whenever you're filing a memo, you have to file the name of the advocate also on whom you have served. And what is the purpose of filing a memo like this?
Sorry.
Order is passed when?
My lord, we in that other colleague gave yesterday, my lord. That's why.
Order is passed on 1/7/2025, asking you to file the memo within 10-15 days. Now you will file the memo. Even in this memo also the advocate's name is not shown. By Monday, if the memo is not filed along with the name of the advocate, the writ petition shall stand dismissed. Yes, next.
Cell number 4. Cell number 4.
My lord. I'm appearing for the petitioner. I
Go
could
on
not
the
receive
next.
the copy, your lordship. Last it.
We'll go ahead with, we'll not consider that aspect at all.
This is a simple case. If the maintenance is 10,000, I am ready to pay, your lordship. The respondent is also taking a handsome of salary of around 55 to 60,000.
What is the amount granted?
20,000.
Huh?
20,000 in the court.
20,000 is granted. What is your salary?
My salary at right now is 60,000, your lordship.
What is your salary?
62,000. 62,125.
If somewhere it is fixed, I am ready to pay and can dispose of the RPFC, Your Lordship.
Daughter is, children,
Two daughters, my lord.
two daughters.
Two daughters.
12 years.
There is a home loan of rupees 7 lakhs. They are not making payment of EMI also. They submitted.
That also you are paying.
Yeah, last occasion,
They
my
have
lord,
not
they
produced that
falsely
copy,
submitted
the same
before the
copy.
honorable court that they are paying the EMI. I am producing all the statements. These statements clearly reflect that I am paying the maintenance, I am paying the school fees, everything is there.
How much is loan, EMI?
7 lakhs, my lord. EMI,
EMI
16,000.
per month?
Yes, ma'am. I am producing the statements also.
Not necessary. Please come. Where is impugned order?
Impugned order is page number 16. Your Lordship.
Number? Agree with the orders passed in IA number 1 in criminal miscellaneous number 207 of 2024 dated 8th January 2025, whereby the family court had granted maintenance of 20,000 per month to the wife and two daughters, to the two daughters. The father is before this court. The IA is filed seeking maintenance of 30,000 per month to both the children. It is a case that of the wife that in the wedlock they're blessed with two children. They were purchased a property by taking a loan from the Canara Bank, and the wife is paying an amount of rupees 17,000 per month towards the EMI. Her salary is what is the salary? Where is it stated?
62,261, my lord. In my assets and liabilities.
62,000?
261, my lord.
The salary of the wife is 62,261. And it's a case that husband is earning a handsome salary and she requires maintenance. According to the husband, is earning 60,000 per month. The wife is earning more salary than the husband.
No, my lord, he is getting 65,000. He is getting 65,000.
65.
Yes.
It is a case that husband, wife is also equally earning. And that she doesn't require any amount for maintenance of the children. The court by order impugned had granted the amount of 20,000, and the court has observed that the material on record prima facie reveals that the wife is drawing a monthly salary, husband is drawing a monthly salary of 65,000, and it's just and proper to direct him to give him interim maintenance of 20,000. Land counsel appearing for the wife, husband, submits that he is paying the loan of 15,000 per month. Then this court had adjourned the matter for that purpose, and it is submitted that he could not he was not in a position to place a document. Land counsel appearing with the respondent wife has placed before this court has submitted that the bank accounts clearly reveals that every month an amount of rupees 16,000 is deducted towards the EMI, is paid towards the EMI. Towards the EMI. And it is submitted that by the land counsel for the respondent wife that she has to take care of 2 children and herself and also pay the EMI. In these circumstances, the amount of 20,000 that is awarded by the court is a just and reasonable amount towards maintenance. There are no grounds to interfere. Next paragraph. Having heard the counsels on either side, peruse the material not record. Admittedly, the salary of the husband is 65,000 and the salary of the wife is 62,000. And for the property which is jointly purchased, an amount of rupees 16,000 is paid by the wife towards the EMI. The wife is not seeking any maintenance for herself. It is a duty of the husband to take care of the wife and the children. In this case, wife is employed. She is paying out of the amount she is receiving. She is paying the EMI and also she is taking care of the 2 children. It's the duty of the father to pay the maintenance to the wife. And in the facts and circumstances, the court had rightly granted 20,000 towards the maintenance of both the children, and this court finds no reasons to interfere. Accordingly dismissed.
Stele number 5, Pradeep B for appellant. S. Manoj Kumar. Yes,
For the
Manjay Gowda.
respondent number
Yes,
1,
Pradeep.
2, 3, madam.
93 days delay in filing the.
IA number 1 of 23 is filed to condone the delay of 93 days. Condone, yes.
This case, my lord, challenging the liability. The ground that the deceased was traveling in a goods vehicle as a passenger, gratuitous passenger. My lord.
What is the vehicle?
Auto rickshaw, goods auto rickshaw.
Auto rickshaw.
Goods auto rickshaw.
Is he the owner of the goods?
No, my lord.
I am the owner of the, I was a passenger in that auto.
Huh?
The owner of the,
You are the owner of the
owner of the.
Owner of the
owner of the auto.
owner of the auto is liable to pay the compensation. That is my ground.
It's there. I'm the
Repeatedly,
passenger
madam.
in that, madam.
Huh?
I'm the passenger in that.
How can be a passenger in a goods auto?
I'm the owner.
What is that? It is
Saying
I'm owner,
that I
I'm
am the
passenger.
owner of the goods.
Not the owner of the auto
Owner of the
rickshaw.
goods I am traveling.
1 minute, what is it?
Auto rickshaw, like.
That's what he's saying. He's the owner of the auto rickshaw.
Yes, ma'am.
Then my
Then
lord,
the court was right. Now, how can there be a direct, how the insurance company will pay the compensation to the owner of the vehicle who is the insured?
I pray for time, man. So I want to get some information. Related to it. It's in Mysore, that advocates. I want to get the information.
This is
repeatedly,
matter
my lord, he was a passenger.
Just I want to get some information.
after vacation. Admit, post for final hearing, call for the DCR.
Stele number 6, Vaishali Hegde for petitioner. S.V. Prakash.
For respondent, we have filed retirement memo.
Huh?
We have filed retirement memo. Our name may be deleted.
Hmm? Where is the retirement memo?
We have filed, my lord. On 9/12/24 itself, we have filed.
What is this memo of retirement? Is this the way the memo of retirement is filed?
Please, my lord, respondents are signed there.
No documents, nothing.
She signed, my lords. In the right side, my lord.
Where is look, wakalat? Wakalat. Show it to them.
She herself to our office and taken all the file, my lord. And saying this to you. That I can say.
Notice to the respondent. The memo is filed stating that the entire file is taken by the client and a bare perusal of the signatures on both appears that there is a difference in both the signatures. Notice to the respondents. You have a interim order,
Please, your lordship.
Our name may be deleted.
matter after vacation. So and so is permitted to retire from the case. delete the name, print the name of the party.
I vote.
Yes.
Serial number 7. Mohan Chandra P.
Okay, for respondent. Also filed connected RPFC number 2, 19 of 2000. Petitioner in connected petition.
Use the mic.
I appear for petitioner, wife. The respondent filed, husband filed RPFC number 124. Wife filed 219 of 2025
Counsel
seeking
for the-
enhancement.
Counsel for the wife is present, no representation on behalf of the respondent and on behalf of the husband who filed RPFC 124 of 2024. List RPFC 124 for dismissal after vacation. Yes, 8.
Right. Ramesh. Page.
Petitioner. But I may be permitted to file the affidavit along with the documents.
Take that.
I'll serve the copy on the other side. Para. Relevant para, you should get it para 5 and 6.
My lord, I'm filed
We'll direct the trial court to conduct an inquiry on this photograph.
Very well. And that, in fact, you will also kindly appreciate.
Yes, please
Now,
come.
may I make
My
a
lord.
submission?
My
But
lord.
He has also contracted second
My lord.
marriage.
Huh?
He has also contracted second marriage. Now, kindly look at
No,
me.
about his contracting second marriage is not the issue. You are blatantly denying the photographs that are filed.
I'm denying. In fact,
According to you, they are the morph photographs. And an affidavit is also filed. I'll direct the trial court to conduct inquiry on this.
Very well. Madam, may I make one submission? Now, you will also kindly, from the date of filing the Milord petition, till today, he has not paid not even a single pay to the Milord. Our children
My
as well
lord.
as the.
My lord, my lord.
Let him pay the Milord interim maintenance which has been awarded by the trial court. And it lends about not 6 lakhs, 10,000 has been
Any
awarded.
interim order in this?
No interim
No,
order.
no, illustration.
File execution petition.
My lord, the respondent stated
The writ petition is filed, agreed with the orders passed in I number 2 in criminal miscellaneous 138 of 2021, whereby dated 28th September 2022, whereby the court, the family court had granted maintenance of an amount of rupees
10,000 rupees for
10,000 to the
the child as well as the first.
10,000 to the child as well as to the wife. When this matter came up on the last occasion, the land counsel for the petitioner husband has filed certain photographs to show that the wife is married, and as such, he need not pay maintenance to the wife. And then this court has directed the husband and the wife to file an affidavit. Today, an affidavit is filed before this court stating that at paragraph
Number 4, 5 and 6.
paragraph number 5, it is stated that as per as a petitioner has mooted for settlement, she was under the impression that there will be an amicable settlement in consequences thereof. Anticipating decree of divorce, an alliance came forward to remarry. And there were some talks going, and the same is subject to getting decree of divorce from the court. Then it is stated that the person who is shown in the photograph happened to be the friend of the husband. Both of them colluded and created the photographs to avoid payment of permanent alimony and also interim maintenance. It is stated that she has not married with the alleged person shown in the photographs, nor leading adulterous life with the said person. And the photographs are fraudulently created. It is also stated that he is married to one Lakshmi on 14/6/2020. And she has also made allegations against the husband. When certain photographs are placed before this court, stating that she is remarried, the wife files an affidavit that she is not married. And on the top of it, it is stated that the photographs are morphed photographs. In these circumstances, this court deems it appropriate to direct the family court to conduct a thorough inquiry by giving an opportunity to both the parties to adduce the evidence if any of them had made such a submission before this court. The perjury proceedings shall be initiated against the party who has made the wrong, who has made wrong submissions, oblique affidavits before this court, before the court. As after conducting the thorough inquiry, the matter shall be sent. The order shall be sent back to this court, and then the registry is directed to list this matter.
Cell number.
In the meantime, I am permitted to execute the order passed by this.
You can, because
Please.
there are no orders. Because I have not.
My lord.
That order itself is not interfered right from the beginning.
Very
good. You were at liberty. Yes.
Cell number 9. Arun Govindraj.
I appear for the respondent husband in this case.
Yes.
I've been served with the copies of 2 applications by the petitioner for perjury and for summoning of documents. I am seeking an accommodation to get instructions and to file my objections.
21/8 not time was sought. Daughter studying in the UK. But if your lordship will kindly, the father not before the court below makes a submission that I will
Let's
take.
see where is the impugned order.
Impugned order,
Come
page number 66, page number 65.
Yes.
No, I may not have much objection against what order is passed.
Registered judicial shall communicate this order to the court with a copy of the order. Yes.
But page 72, if your lordship will kindly see paragraph 10.
No, what is the order now?
Maintenance, not 55,000 rupees per month has been awarded to the wife. And though the court not records at paragraph number 10 that the husband has stated that he's taking care of all the entire educational expenses of both the children and he will continue to do it, that does not find a mention, my lord, in the operative portion of the order.
Let's see that. Where is the mention?
Paragraph number 10, page 72. May I read? The respondent states that apart from the educational expenses of the children to be borne by him, he has other liabilities of payment of loan, so and so. The respondent has produced the hospital bills, residential statement of his daughter, school fee receipts of his son, bank statement, education loan statement. All those documents at this juncture indicate that the educational fee of both the children, loan installments are borne by the respondent, and even the expenses towards the treatment of the mother of the respondent as well. But operative portion at page number 74. IA1 filed by the petitioner under section 36 of the Special Marriage Act is allowed to the extent that the respondent is ordered to pay the petitioner interim maintenance of 55,000 rupees per month from the date of petition, that is 1/2/2023.
Subject to observation made at para 12.
Para 12 is,
No, that is.
para 10 it should have.
10 it should have been para 10. There is nothing in para 12.
And the other thing, my lord, he has suppressed 2 accounts. He has that I will file perjury proceedings before the family, before the court. I have filed it over here.
My lord, there are 2 children to this marriage. The first is a daughter. She's studying in the UK. She is now in her final year of her studies. Towards the daughter's education itself, I have paid a sum of more than 75 lakh rupees. Now, these applications that have been filed now by the petitioner, coming fast and furious, come on the heels of the statement of account that I have filed before the family before the. No. I have paid 93 lakhs towards them.
No. We'll not go into the accounts and other details.
Not accounts. I have paid 93 lakhs. The amount that is to be paid is for my daughter's education. I have paid for my daughter's education 76 lakhs. As soon as I filed this statement before the trial court, these applications for perjury and for summoning of documents arise. Which is why I will bring it to your lordship's attention. I will file these documents before your lordship. Your lordship will be able to see that I have not only satisfied not just the arrangement that I had with my wife, but also I have gone far and beyond. Your lordship will see that she also, in this very same order, kindly turn to paragraph number 9. She earns a salary of 45,000 rupees.
What is that you want in this
No,
order?
Not 55. The educational expenses, my lord, are not covered by the order.
So.
My son doesn't go to school. He doesn't go to school.
My lord, whatever the expenses of the children, educational expenses, if the father, my lord, as is undertaken before the trial court, if he undertakes to pay.
What we do is, we'll not go into any other aspect. You have not questioned this order of the family court.
Not yet, my lord, because my client is not in country.
1 year, my
That is
lord.
not. No, here it is subject to observations and map made in para number 10.
1 year, my learned friend says 1 year. I've been served only in 5/8.
What you're served?
The copy of this writ petition has been served only on
Forget
5/8.
about the copy of the writ petition, this order.
Yes,
It
madam.
is about para, instead of saying made in para 10 above. Instead of that, the court said para 12 and above. That's the only clarification we'll give in this.
No, my lord. First of all, the clarification that they want is that they want me to continue to pay for my children's education. My daughter's education is already paid for. My son does not go to school.
Why?
Because he resides with the petitioner and she does not send him to school.
What is the age of the petitioner?
17.
No, he's 16-year-old boy.
The 17-year-old boy does not go to school.
Because of the parental discord, my lord, he dropped out. He got into certain habits and he has dropped out. He's undergoing psychological treatment.
No. There is no problem with the child. He does not go to school. She is seeking in her statement, in her application before the trial court, she seeks 45,000 rupees as conveyance to take him to school when he does not go to school.
But he was studying.
Now she has been awarded 55,000 rupees a month. She stays in my house. She earns 45,000 to 48,000 rupees by her own affidavit as a teacher. But she does not send my son to school. Every single expense of my son, if he goes out, he texts me and says, "Please pay, Papa, please pay." I pay on UPI from wherever in the world I am. Now there is no expense that she is incurring. That there is no reason to even increase this 55,000 to any amount. I will place that information before your lordship. Till today, I have not shirked. I have paid more than 93 lakh rupees for their education.
So you're saying that the daughter's fees are due?
All paid. She's studying in the United Kingdom. She wants to be a policewoman in the United Kingdom. I have my arms were twisted by the petitioner. I was forced into paying for that sort of an education. 76 lakh rupees has been paid. That as soon as I bring that to the knowledge of the trial court, these applications follow. I will place it before your lordship. Your lordship will be able to see very clearly what this is all about.
Yes, Mr. Lord, I am not asking for enhancement. I think my learned friend has not
But
heard
he
me.
says it's already paid.
Not paid, my lord. 17. I have borrowed money from my father to pay the last installment 2 months ago. Let him file an affidavit that he is paid.
All the vouchers are here.
17 lakhs, my lord, is the maintenance due as of today. Order was passed on 23rd of August.
Not maintenance.
Even the not paid, my lord. My father has paid.
I have produced the bank statements to them.
Ask me to file an affidavit.
It's not about.
I will file the affidavit.
According to the counsel for the petitioner, the father has not paid the last installment of the school fees, college fees, amounting an amount of rupees 17 lakhs.
That is not the writ petition at all.
You have to pay the medical expenses. Educational
No,
expenses.
that's
you
not
have
their
paid.
writ petition at all. They're asking for enhancement of their, of the 55,000 rupees. That is the prayer in the writ petition.
Not educational, apart from educational expenses, I'm asking for enhancement. I'm making a
He
submission
is
before your
asking to
lordship.
set aside the order of the trial court and for this court to grant him what he sought in that application. That is his prayer.
Which includes educational expenses. My learned friend has made a submission before your lordship today.
What are your grounds? Let's see the grounds.
Yes.
Page 8. She admittedly has an income, paragraph 9, of 4,23,800.
Let's see the grounds.
Para
What is
13.
it?
His grounds, his grounds.
The
Para
minus-
13.
Para 9.
Paragraph 13 at page 9. Minor son school fees about 73,000 rupees.
And
He's
he's
doing,
not
But he
going to-
doesn't go to school.
he's doing national NIOS. He's doing his 10th standard now. That's why I said 73,000 rupees per annum. Daughter's educational expenses would come to 26,75,000 rupees per annum. Failure to make the above payment could result in the loss of their seat in the educational institution. My lord, this is all. My lord, though I have asked for enhancement,
Their instructions only as far as this aspect is.
educational expenses.
I have already filed those papers. I will file them if my party is in Turkey. For him to get an affidavit is difficult. I will file it with a memo. I will get instructions.
And answer for the petitions of the sir. The college fees of an amount of rupees 17 lakhs is due according to the
No,
respondent.
I have paid, my lord, through my father is paid.
Is paid by the mother with the help of her father, borrowing the money from her father. According to the respondent father, he has been taking care of the educational expenses and so far he has paid 75 lakhs.
Yes, yes.
He has paid 75 lakhs and by the next date of hearing, he'll get specific instructions with regard to the 17 lakhs that is paid by the wife. This is matter on Wednesday.
My lord, I won't be able to file an affidavit on that date.
No affidavit, I said, get instructions.
I'll get instructions.
24/9.
And
For
the
admission.
maintenance is not, 17 lakhs is the arrears due, my lord, not.
There is more than enough has been paid, my lord. I will
You can
place
file
it.
the
Very- I will-
execution.
very-
The execution, yes.
Cell number 10 for admission matters.
It is,
Upannappa
my lord,
SP.
on that very point, it is being heard tomorrow in the civil, before the civil judge. So there, every time I come up before the civil judge and I make a submission and I justify how we have paid it, these applications follow.
Yes.
But in 10.1,
10.
and I have deposited the amount. There is a difference in calculation of the interest for an amount of rupees 791. That I will deposit tomorrow.
Why don't we hear this?
Yes, ma'am.
Why don't we hear this appeals?
But my lord,
After
without
vacation-
depositing, making statutory deposit appeal itself is not maintainable.
No, we have deposited. There is a
There is
difference
deficiency in.
difference in calculation of interest. I will accept the registrar's calculation. I will deposit.
Why, first of all, against all appeals for 2017.
Yes.
Now with the delay, all these appeals are filed.
Yes.
And you don't, how many times this matter has to come?
I have
go?
I have deposited it. I have calculated interest.
You have to calculate as per how it has to be.
Madam, I have calculated.
Whatever the calculation that is
Yeah.
made by the office, if it is
So,
not right,
I have instructed my client to bring DD. Today they will bring and we will deposit within.
this is matter on Tuesday. By that time, if the statutory deposit is not made, on that ground, the appeals shall stand dismissed.
And
Maybe on
one
Wednesday.
more, my lord, in 10.1, I may be permitted to carry out amendment right now, my lord. Some.
10.1 petition is, appellant is permitted to carry out the amendment. Yes.
Maybe on Wednesday.
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 Argue the matter on that day, we'll dispose it of.
Cell number
It has to be remanded back, my lord.
Whatever
That
it
is
is.
the only thing.
Either ways we will do. Yes.
Principal employer is not media party. That reason may be matter remanded to the.
Yes, we will do that.
11. Keshava Ragnotri for petitioner. Nagarajesh Jain.
For respondent.
Respondent.
No Passover today.
Because I got some person. Here they have deposited 94,000. I may be permitted to withdraw that.
The amount deposited, the petitioner, the respondent is the amount of an amount of rupees 92,000 that is
94,
deposited.
94.
94,000 that is deposited by the petitioner. The respondent is at liberty to withdraw. This is this matter after vacation. Yes, 12.
Cell number 12.
It's pay for a
My lord, my bill for the respondent, only the petition is given, madam. That supporting document is not served to us.
You have not filed any support.
No, supporting
You
document.
have
is
the order
petition.
copy,
No, madam.
order copy of the trial court.
Only order copy of the trial court we have filed the along with appeal memo.
If you have the order, That is also not served.
No,
Then what
sir.
is served?
Only petition, madam.
Serving.
I served the copy, madam. Correct.
Yes, list this matter, look at it, if it is any day is there, otherwise after vacation.
Nine.
Yes, 13.
Till number 13.
This case appear for external. The trial court has dismissed the petition
On the ground,
on the ground that the permanent alimony was awarded. Well, the appeal is pending before the honorable court.
whether that order is suspended,
Yes.
permanent alimony order is suspended.
Pursuant to the
Yes,
order.
ma'am. The trial court judgment was suspended, ma'am.
No amount is granted as, no amount is directed to be released.
No, yes, my lord. He is deposited before the trial court, but I have not taken
Yes,
that
not for
amount.
the,
Not that, in the MFA, any order is passed, if you have the necessity, you can file an application before the court. Court would release some amount.
But permanent alimony is more, lesser amount was awarded.
That will be, whatever is the amount that is deposited by him. If you are in a need of money, you should file an IA. Court will direct court will, pass a direction so that some amount will be released.
Yes, my lord. We have tried, filed the application.
We'll keep this pending. This is matter after vacation.
please.
Make your efforts at the request of learned counsel appellant. 14.
Sampath A.
Mr. Lordship directed me to ascertain the salary of the petitioner husband. Lord's petitioner retired during the pendency of the petition. It's before.
Pension, how much is getting?
The pension is drawing 23,000. Regarding the documents, my lord, is sent me in the WhatsApp which are not clear. Should produce.
What is the amount that is granted by the court now?
It's 10,000 is granted. Lord, there are two sons, my lord, who are petitioner is aged 65. All the sons are with the wife, my lord, and they're not coming to settle with me, and I'm living separately. Lord, I deposited, my lord, 5,000 of the 5 lakhs of the amount as directed by this honorable court. So I made a submission that 5 lakhs be released in favor of them. I will continue to pay the, my lord, 5,000, my lord, because I also have medical
Representation
bills.
on behalf of the respondent counsel, the petitioner is present. This is matter after vacation.
Please, obliged.
15.
Till number 15.
Appear for the petitioner, my lordship. The petition is preferred by the father of the respondent number 1 and 2, my lordship. The respondent number 1 and 2 are represented by the mother, my lordship. Now, respondent number has attained 19 years, my lordship, and court has ordered for monthly maintenance of 8,000 rupees for respondent number 1 and 5,000 rupees for respondent number 2, my lordship. Here, my lordship, the petitioner has taken care of the complete education expenses.
1 minute. Please come to the cost title.
Cost title.
When the first respondent has attained majority,
When pending trial, my
no,
lordship.
there should be a date for that.
That I need
So
to-
as far as the second one is concerned,
He is
she
minor.
still a minor.
Yes,
So he is a minor.
Yes,
What
ma'am.
is the amount granted by the court?
8,000 rupees for the first respondent, my lordship, per month from the date of the petition, and 5,000 rupees for the second respondent, my lordship.
So you're questioning which part of it? On what ground?
My lordship, the mother of the respondent is a staff nurse. She is earning more than 1,10,000 rupees, my lordship. And the petitioner is a police constable, my lordship.
He's earning?
He is earning 60,000 rupees per month, my lordship. And he has a mother, dependent mother, my lordship, who is age old of 80 years, and nearly 15,000 rupees as to for medical expenses, my lordship. He has to take care, and a rented house, 15,000 rupees he has to take care, my lord. Apart from that, he has taken care of education expenses.
How much you're paying towards education expenses?
My lordship, respondent number 2 is a 15, he has failed in 10th and his school dropped out. He is not doing anything. He has some other habits.
We will have it on Monday. Please get the entire details. What is, when he
My
attained
lordship.
majority? Who?
Yes, my lordship. Kindly
first
see,
petition?
last year only, my lordship. Kindly see Annexure D series, my lordship. These are the educational expenses receipts, my lordship, for medical college.
Page number,
Page
report.
number 45, my lordship. Annexure D1, SS Institute of Medical
40?
Science. 45, my lordship. He has
What is
paid-
he studying?
She is studying MBBS, my lordship. He has paid that. She has just
No, you see this 50,000. Where?
50,000 and backside also, my lordship. In
No,
page number
when he's paying, how, like this 50,000 for for 6 months or every month.
Government sheets he has taken, my lordship, in the SS Medical College. He has paid 1 lakh and odd, my lordship. 1 lakh he has paid through scanning, my lordship. Page number 46, 45 and 46 are the for the thing. Receipts are with the mother only, my lord. That is the thing we couldn't put it. It has been marked also, my lordship, before the trial court. Trial court has not considered, and all the other expenses also he is taking care, my lordship. From the school receipts also is there, my lordship. These series completely are the receipts which were spent. School receipts, my lordship, page number 58, my lordship. That is also marked before the trial court, my lordship.
Then counsel for the petitioner submits that the first respondent has attained a majority during the pendency of the petition, and in fact is taking care of the entire educational expenses of the child. And the wife is working as a staff nurse, and the salary is 1,10,000, and the salary of the petitioner was a police constable is 60,000. Considering all these aspects, they shall be stay of all further proceedings on the condition that you shall continue to pay an amount of rupees 5,000 to the second respondent, and arrears also at 5,000. As far as the first respondent is concerned, he shall continue to pay the educational expenses.
My lordship,
notice to the respondent.
One observation. The second respondent is the school drop. The question of the father is his school dropped out and he has very bad habits also.
Even if it is a school dropout, still the mother has to take care of him. That will not interfere.
Please.
Yes. Notice to the respondent.
Cell number 16 urgent. Cell number 17. PC for petitioner. Nirmala K. for
Petitioner.
respondent.
And for the wife and the daughter. NHA is the impugned order, wherein your lordship, I'm fairly submitting as for the child is considered. I don't have any.
Come to the impugned order. The second petition is entitled, that's a.
Yes, 10,000 for the.
Petitioners, that's only 10,000 that is granted.
10,000, I'm not on that. The question is only here, your lordship. She's in a better position. She's in a higher, both are working in a KSRTC. And my salary, your lordship, that is 34,357, where she is getting 37,787. My only
lordship, kindly see the page number.
Please wait, let us complete the submission. Yes.
Only paragraph number 14, the learned trial judge comes to a conclusion that at this pre-trial stage, there are no material before this court by both the parties regarding the income of the petitioner as well as respondent, wherein he has considered the assets and liabilities affidavit, when based on that he has made passed an order ordering maintenance of 10,000. My only humble request is that both father and mother both are equally responsible to bring up the child. So what
is the school fees of the child?
Lordship, exactly I don't know the figure.
Court has observed that he is studying in so and so. School fees, on perusal of the school fees and receipts paid, it is clear that petition number 2 is so and so. School fee is on higher side. What is the school fees?
School fees comes around more than 1.5 lakhs, my lordship, per annum. Exactly, I don't know the figure, but it comes more than that. And it is apart from that, she has to pay uniform and other things. And take home salary is 19,000.
School fees itself is coming to 12,500. You say equally. If it is equally 6,250. And apart from going to school, he requires some other things also.
I'm ready to do everything for the child, even the school.
It is for the child only.
School expenditure. Only my only grievance is that, your lordship, where she being in a higher post and she is
just 3,000 difference.
Correct, your lordship. Where I have made only my one concern is that she has deserted me and gone. The divorce petition where it is pending, where only my submission, both being working in the same department and thinking about the welfare of the child, they both are willing to rejoin. That would be appreciable. That is all my
My
submission.
lordship, he has got another relationship and he is leaving that. That is
Please
very much.
come. Agreed with the orders.
Kindly
passed
see
in-
the page number 23, that is the reasoning.
Number
He-
2 in criminal
he
miscellaneous
takes-
number 3 of 2024, dated 25th November 2024, whereby the court had granted 10,000 as maintenance to the child. The husband is before this court. The wife had filed the IA number 2, seeking maintenance of 20,000 each per month to herself and to the daughter. And also to pay the educational expenses of the daughter, and 30,000 towards the litigation expenses. In this case, the facts are that the wife and husband, both of them are working. The husband's salary is 34,367. The wife's salary is 37,007.
There I would like to come, that is a reasoning, Your Honor. She takes home salary is 19,506, my lordship.
37,787, and the take-home salary is 19,000.
506, my lordship.
19,506. The court had considered both the aspects and also the fact that the boy is studying in a school.
Daughter
is studying in a school where her educational expenses are very high, and according to the land counsel of the respondent, it comes around more than 1.5 lakh per annum. Court had granted 10,000. Next parallel, and counsel appearing for the petitioner, husband submits that the wife had deserted the husband and staying separately. He has a responsibility to take care of the child, but she is earning more salary than the husband, and it is an equal responsibility of both the parents. It is submitted that if there is any scope for reconciliation, the husband is ready to take back the wife. Next paragraph. Land counsel appearing for the respondent, wife submits that the wife is not interested for a reunion.
No, we are ready, but he has to come. He is not ready to come here, come to Mysore and live with her, my lordship.
Submitted that
In the mediation,
if
he
the
said,
husband is ready to come to Mysore,
where she and her daughter is living.
Huh?
Both are living in Mysore.
and then the wife has no objection for the reunion. The reunion, considering the totality of the facts and having heard the counsel on either side, that is the material. Considering the income of both the parties and the fact that the wife alone is taking care of the child and the educational expenses are on the higher side, the tribunal, the family court had rightly granted maintenance of an amount of rupees 10,000, and this court finds no reasons to interfere. As far as the mediation aspect with regard to the reunion of the parties, this court deems it appropriate to direct both the parties to appear before the Bangalore Mediation Center.
It's already in the previous year, previous.
What do you say?
Mediation is got over, my lord.
Whatever she did not participate with,
No,
because the
we
active
did.
participation was not
No,
there.
we did. They are not coming forward that.
They will
My lord.
come.
Kindly see them.
Both the parties shall appear before the Bangalore mediation, the Mysore Mediation Center on 20, not on 20, on 8th of October. Yes,
Please.
Number 18. Sridhara B for petitioner. Upagya.
Hearing for the respondent in this matter.
It's interim maintenance. Against
where is impugned order?
the annexure 86, page number 86.
86.
Yes.
The petition is hereby directed to pay 25,000 per month
Yes, Your Honor.
to the child.
Yes, Your Honor.
What is your income?
Take home salary is a 45.
45,000.
Yes, Your Honor.
Is the wife working?
Yes, Your Honor.
What is her salary?
50,000. As per 55, she mentioned.
The baby is suffering from autism, Your Honor. The earning of the petitioner is more than 40,000. Your Honor, may kindly see the order sheet.
She said so, 45,000.
8,88,000 is annual income what he has assessed in the year 2021-22.
So considering all the aspects, the court has granted 25,000, not for the wife, it is for the child because she needs treatment apart from education. I have produced the document before this honorable court, which clearly establish every year nearly 3,50,000 to 4 lakh is coming expenses of the baby. Now she has admitted for first standard. 1,61,000 is the admission fee and 70,000 is the shadow teacher fee. And every month she need to spend nearly 10 to 15,000 for therapy. Apart from transportation.
Otherwise, we'll do one thing. Whatever is the whatever are the expenses of the child, let it be borne equally by both the parents. It is advantageous to you also.
Yes, Your Honor. That's why the court has granted 25,000.
No, I'm saying
that
instead of
expenses is
25,000.
Yes, Your Honor.
Yeah, equal one. Instead of 25,000, if it is 25,000, how much it comes? 25 into 12, it comes to 3 lakhs. But what you are saying is it's more than 3 lakhs.
It's only for education, apart from food, shelter, clothing, other medical expenses, Your Honor. That is the transportation for therapy. She has to be taken by
Let's
auto.
take it 1 minute. No, according to you, it's coming to 4 lakhs per annum.
For only therapy and education.
So it comes to 2 lakhs. So 2 lakhs is per month. It is 16,000. 666. Court has granted 25,000.
Your Honor, may kindly see her earning is only 50. If she do more external duty, then only she will get 55,000. It is not compulsory payment what she is taking. Now she needs her food, clothing and everything, medical expenses. That's why the court, considering all the aspect and income of the petitioner, it has granted 25,000.
That is equally.
Only educational expenses, half of it is coming to 17. Then what about the maintenance?
The educational expenses.
She has to take the care of the baby, Your Honor. She has to send, one second,
As per
one
entire
submission, Your
education
Honor.
expenses, they are stated, filed before this honorable court to 1,61,500 rupees.
But she says 4 lakhs.
No,
No, no,
Your
no,
Honor,
I
it says wrong submission. There is no.
Your Honor, may kindly say, I have
No
produced the
documents
document, it is
produced
before the court.
1,61,000 only.
That is school fee. 1,61,000 is
That
the
is
school
only.
fee, van fee, and tuition fee. That
There
is.
is a
It is there. I have filed before the court itself in the counter itself. As per the direction of the court.
So it is first, the school fees is 1,61,500.
And the bank statement reflecting the payment made to shadow part payment 40.
Let's see, where is it?
Page number 7.
How much you are paying?
40,000 partly paid, Your Honor.
Where do you get?
Page number 7 of the bank statement. 30,000 she has to pay, Your Honor.
Your Honor, this is the part of the payment of 40,000. The 1,61,000, whatever.
No.
paid.
It's not that shadow teacher payment is apart from the school fee, what the school fixes, Your Honor.
The parent has appointed a dedicated shadow teacher with extra cost.
Yes, Your Honor.
In the classroom. That you can read, I think.
Next, Your Honor, may kindly see
40,000, you have paid 40,000. How
part
much?
payment has been done. Remaining 30,000.
If you people at least wait for a minute.
Yes, Your Honor.
And understand what is the question, it is easy.
Yeah,
Because
yes.
ultimately what you know is not relevant. What
Yes,
I have to understand is relevant,
Yes, Your
isn't
Honor.
it?
Yes, my lord.
So, what is, when you are saying 40,000, what is it, what it is for monthly, how much it is?
Total for the year is 70,000.
teacher, how much?
70,000, Your Honor.
70,000. Any other thing apart from this?
Apart from that, this is the treatment charges which I have
Where do you get that?
page number 17, Your Honor.
Page number 17.
Yes, Your Honor. 17 to 20 are all medical treatment expenses. Earlier, she used to be treated with the Pragyan Child Development, where she used to pay 23,000, 15,000 every month.
Not every month.
According
it's a
to-
therapy, speech therapy.
According to the
Therapy.
classes,
Therapy.
according to the classes, they used to fix the charges. That is what she has paid.
How many
That
times? No. Instead of vaguely filing these kind of receipts.
It is
if
not
she can-
vaguely, Your Honor. Your Honor may kindly see the receipt of
You
October.
file a receipt. Court has to understand how often it has to be done.
It
So
is
if you can place before the court.
Your Honor, may kindly see the
Please
page
come.
number
The
20.
counsel for the respondent shall place before this court the correct breakup of the school fees, the shadow teacher fees per month, and the therapy, whatever the therapies that is undergoing, whether it is how many times in a week. Clearly, what is the monthly expenditure that is spent? If it is variable, what is a variable expenditure has to be stated in a format and placed before the court. This is matter. When can you play? When can you file?
26th is the payment
Please
date.
wait. Yes.
24th.
Yes, 24th.
23rd, it may be taken.
23rd. Yes, next.
Cell number 19, Rangaramu B, Anisha Acharya.
As per order of this honorable court, I am regularly paying the 15,000 per month to the
You are for
respondent.
the petitioner or respondent?
For petitioner, sir.
Hmm.
For petitioner. I have filed a divorce case before the family court of
Submitted
Bangalore.
that as per the order passed by this court. The petitioner is paying the maintenance, no representation for the respondent. Interim order earlier granted is extended until further orders. This is matter in the month of November.
Much obliged.
20,
Much obliged.
Anila, for petitioner, Timothy ML.
Appearing for petitioners, my lord, and for the respondent, my lord. The impugned order, page number 57, my lord.
Yes.
Serial number 3, my lord. In view of the said arrangement, both petitioner and first respondent further agreed that respondent 1 shall have visitation right in respect of respondent number 1 to 3 times in a year, more fully during summer vacation 3 weeks, Dasara vacation half of the vacation, and during Christmas half of the vacation, so such during the interim vacation. In GNWC 21/2022 disposed on 21/11/2022, my lord. The respondent violated the order from past 1 year. She is not allowing father to take the child to his native place once in all these 3 years, 3 times in a year, my lord. So I filed this writ petition, my lords.
So this is executing court of the Lok Adalat award.
No, Lok Adalat only, my lord. The subordinate bench also passed an order. Who will violate the order of this honorable court, then they can shift the custody of the child, my lord. Because
Counsel, first of all, don't go to the judgments. First, you tell the court what is the maintainability of this writ petition.
she has violated.
Please understand.
Yes,
Lok Adalat award is passed.
Yes, my lord.
According to you, there is violation of the order of the Lok Adalat.
Yes,
then you
ma'am.
will file a writ petition before this court. Under which law?
No, my lord. My prayer is for writ of certiorari, my lords.
Yes, please come.
She has violated the order from the past 1 year. As soon as she got the divorce and as soon as she got the permanent alimony, he is not sending my child to during the vacations, my lord. I have given the police complaint in annexure.
Can a writ be maintainable? To issue a writ of certiorari, quashing the order passed by the principal judge family court. Now, an order that is passed by the court, GNWC, in view of the joint memo filed by the parties, have to be quashed in the writ petition because there is violation of the order. Is it what you want?
No, my lords, because the wife is not allowing my child to take for any of the vacations, my lords.
Come.
I have given the police complaint also. Mail also written. She is not ready to send. They filed the objection. They are ready to send.
They filed the.
My lord.
If they are ready to send, please take. But I will not entertain this.
My lord, we have no objection to take the child in the
Both
during
of you,
vacation.
whatever you want to do, you do.
Vacation, ma'am.
No,
But this court will not interfere, and this is nothing but a mockery.
My lord, direct the respondent to.
The present writ petition is filed, passing seeking for the following prayer. Extract the prayer. Both the parties have filed a joint memo before the court, and the court has, in the light of the joint memo, the court has passed an order whereby the visitation arrangements between the parties is agreed. Now the present petition is filed stating that the wife has failed to honor the order passed passed in the as per the joint memo or as per the terms and conditions of the joint memo. The wife is not sending the child. Please understand.
Yes, ma'am.
Is not sending the child. Hence, the present writ petition is filed to set aside the order passed in GNWC number
21/22.
in GNWC number 21/2022 and is sought for a writ of certiorari. When basing on a joint memo and the court has passed an order dated 12/11/2022, if there are any violations of the said order, it is for the parties to execute the order. Because the order is not complied by the wife or complied by one of the party, that cannot be a ground to approach this court to set aside the order passed in GNWC. The writ petition as filed before this court is not maintainable and the same is dismissed as not maintainable. The petitioners are at liberty, the petitioner is at liberty to avail the appropriate remedy available to him.
Case number 21, Veerabhadraya MC for petitioner, Pavan Kumar S for respondent.
Respondent in this case, my lord.
Yes.
Lord, trial court has passed the order for 20,000 maintenance, my lord.
Is there any interim order in this?
Yes, my lord. The court has reduced for 13,000, my lord.
Though the petitioner for the learned counsel for the petitioner is not present, counsel for the respondent is present. This is matter for dismissal. Give some date in the next week. Yes, next.
13th. Next week.
Yes.
26/9. Cell number 22 for final hearing, Ashok N. Patil.
Yes.
Yeah, for respondent's claimants, my lord. Ready, my lord.
Yes.
Challenging, my lords, on the point of negligence and quantum.
Mm.
Now my learned friend has not produced some few additional documents. In that way of the matter, my lord, the matter requires remand.
What is the document that he has
Those
produced?
are, my lords, the bank statements he has produced, my lords.
With regard to?
With regard to say that, my lords, he is having higher income than what the tribunal has considered. Therefore, my lords, in that scenario, my lords, if he wants to say that, my lords, his income is higher,
Shall be,
the matter needs to be remanded. my
where
lords,
is the IA?
It
IA
is
number 1 of 22. Yes, please come.
keeping open all the contentions, my lords, your lords may.
Where the liability is on insurance company.
Liability is fixed on the insurance
Agreed
company.
by the award passed in MSC number 5582 of 2018 dated 3rd May 2019 and 19.
But I have questioned not the negligence, my lords, your lords
Both
keep
the-
open.
both the-
And my lords, one more point.
Yes, yes.
The interest is, my lord, awarded at 7. my lords.
Nothing, I'm not deciding anything.
It could be, my lords,
The-
observe
both
that
the-
6% could be, my lords.
Both the appellant, both the insurance company as well as the claimant are before this court. The insurance company's appeal is MFA number 6655 2019 and the claimant's appeal is MFA number 1936 of 2019. The claimant had filed I number 1 of 2022 showing the placing some bank accounts before the court that his income is
1 lakh, my lord.
1 lakh per month,
Yes,
but the court had considered
16,000 only.
but the court had considered the notional income. The insurance company is before this court questioning the negligence
And
as well as
quantum
the quantum
and interest.
quantum and the interest. The interest that is awarded by the court is 9%.
7%.
7%, and the same needs to be reduced to 6%. Then coming to this bank account that is IA number 1 of 22 that is filed before the court, that cannot be decided by this court. And in those circumstances, it has to be remanded back to the court. Accordingly, this court is passing the And IA number 1 of 22 is accordingly, this court is passing the following order. The award dated so and so is set aside. And the matter is remanded back to the court. All the issues are kept open and the parties are at liberty to adduce the evidence, the entire record to be sent. Amount in deposit shall be kept in a fixed deposit.
Cell number 23.
Obliged.
23, GM Anand, appellant.
And for appellant.
Deep B.
Climate appeal.
For the,
Yes, Pradeep?
yes, Madam. Only, Lord, earlier, my lord, we have preferred an appeal. Our appeals has been dismissed, my lord. The claimant's
So it
appeal
has
is
to be considered only their appeal with regard to enhancement.
enhancement. Pain recovery order is passed, my lord.
Already
Pain recovery
passed.
passed.
That is confirmed.
That I have questioned before this court, my
That
lord,
is
that has been dismissed.
So please come to this, the
Para 60.
1 minute. Both are connected appeals.
Connected, my lord.
What is the
Para,
MVC?
para 16, my lord, MFA 2258 of 21. Arising out of MEC 791 of 2016. Minor, my lord, 7-year-old girl
Next.
was sustained injuries.
No, MFA is 1707.
That is, my lord, 792 MEC.
Where is the table in 791?
No, my lord,
Para 60.
there is no table, my lord.
No
There is
table.
no table.
How much is awarded?
1,31,490.
So we will apply, it's a case of death or injury.
Doctor not examined.
Huh?
Doctor not examined.
Doctor is not examined, but she has 7 years old girl. 3
Then
fractures.
what about the disability and all? How will we know? To give even for, as for Dr. Master Mallikarjun, unless and until the disability is there, we cannot decide. Shall we remind Pradeep for this?
Now, this stage, my lordship could have enhanced some amount, my lord. Then
What is that sum amount?
In all it's in marginal enhancement.
Let's see.
pain and suffering, my lord, 60,000 granted, my lord.
Let's see how, what are the injuries? Left iliac wing
please, madam.
fracture, left clavicle fracture.
Clavicle and candular
of
fracture, mandible.
Multiple left posterior shoulder, punctured wound over the left abdomen. How much is granted towards pain?
60,000.
60,000.
How many fractures? 4 fractures.
3 fractures, my lord. Rest of that
80,000.
laceration and puncture wound, my lord.
80,000. Then
Medical, my
Medical
lord,
bills, how
21,000 is the medical expenses, my lord.
how much?
30,000 awarded, my lord.
Medical bills.
15,000 medical.
30,000.
30,000.
30,000 awarded.
So loss of
Nourishment
income.
food,
16,000.
For rupees 21,890
medical expenses is, my lord, 21,890.
against her claim of 1 lakh. Why it is not considered when 1 lakh?
1 lakh is not, they have not produced the 1 lakh.
So let's take it
The
30,000.
bill, my lord, exhibit P22. And careful perusal of the above bills, the bill at exhibit P20, 6,500, out of which 5,300
No,
discount was
medical
given.
expenses are 16,490.
Yes, my lord. MSCT awarded 30,000, including
Did you get that?
in para 17, my lord.
Para 70.
Para 17, from the bottom 4th line.
Pain and agony so and so.
Parent agony
Post
60,000.
award towards pain and suffering, 30,000 towards medical attendant conveyance.
And then nourishment, including
So what we
medical.
do is this medical bills as it is we will take.
Please.
16,490.
490.
How many days he was in hospital?
11 days, my lord.
Huh?
11 days.
11 days. So towards that we will grant 11. Attendant, transport and all, 11,000. Then loss of income to the parents,
Parents not awarded.
that we will award.
Please. 2016 is the accident.
Future treatment implant is
1
there.
minute. Because without examining the doctor, you cannot ask for all this.
9,500 is
9,500.
500.
3 months?
Please.
28,500.
28,500.
500.
So loss of income to the parents.
Amenities 25,000 awarded.
50? At least there is anything on record to show that some operation he has undergone?
Regarding that, my lord,
Exhibit P 23 and 24, it
Uh-huh.
shows exhibit P
discharge
20.
summary, exhibit P 23 and 24,
What they say?
not discussed in this.
Some 20,000 towards future medical expenses. It comes to 2,15,990 against 1,31,490. So let's go to the next one. This is MBC.
MEC, my lord, 791
Hmm.
of 16, arising out of MEC.
Next.
MFA 2258 of 21.
Next,
Next, my lord,
792.
792, in this case also, my lord, there is no doctor evidence.
Where is
One-
that?
Next, para 18, my lord.
How much is awarded?
Global
40,000
compensation
global.
Uh,
fracture of both the bones of left forearm. She is Taylor.
Let's
Mother,
see.
There is,
daughter and mother.
there is no evidence in that regard.
Daughter and mother.
No, that they will get for the under the head of pain and suffering itself when there is a
40,000.
fracture.
40,000.
40 is on the lower side. Let's see. Let's read it.
Para 18.
Injury to her left forearm apart from other simple injuries. So there is no fracture.
They have not produced discharge summary of that. What type of trip?
21,480 medical bills are there.
Medical bills are there. 30 para exhibit P 10, 30 and 39.
So medical bills will take medical bills.
Please.
21,000. How many days was in hospital?
One day.
So globally we'll grant another 20,000. Yes?
Yes, fracture, my lord.
Huh?
Another 50,000. 50,000 global. She's
50,000.
Taylor.
I said another 20,000. Another 20,000.
I said another
Additional
55.
50,000. There should be some basis for giving another 50,000. What is it, Pradeep? Ready for another 50,000? That's without any basis. So we'll have 60,000 globally. Please come. Agreed with the award passed in MBC number 791 of 2016 and 792 of 2016 dated 20th March 2019. The claimants are before this court seeking enhancement of the compensation. The tribunal has fixed the liability, that has held that the principle of pay and recover will apply, and the insurance company is liable to pay and record the same from the owner of the vehicle. The same has been questioned by the insurance company before this court. You have the numbers, Pradeep, MFS?
Please.
You have the numbers?
MFA number.
No,
Please,
of
madam.
your appeals.
Yes, madam.
Write on a paper and give. He submits that they have filed MFA so and so, and the same came to be
4104 of 19.
dismissed by this court by confirming the order of the trial court. Next para. MBC number 790, MFA number 2258 of 2021, arising out of MBC number 791 of 2016. The tribunal has granted the compensation of an amount of rupees 1,31,490. In this case, the claimant had sustained the left iliac wing fracture, left clavicle fracture, B/L condylar fracture of mandible. Next, multiple laceration of the left posterior shoulder, punctured wound over the left lower abdomen with foreign body. On behalf of the claimant, PW1 was examined, but no doctor was examined. Examined herself, examined the claimant as PW1, and no doctor was examined. The documents are filed, exhibit P5, P23, P24, and the OPD books, or that is exhibit P25 to P27, reflects the nature of injuries, and also filed P7 to P22 for the injuries sustained by for the medical expenses. The court had granted an amount of rupees 60,000 under the head of pain and suffering, 30,000 towards a medical attendant conveyance, nourishment and other incidental charges, 25,000 towards the loss of amenities. Altogether an amount of rupees 1,31,490 is granted. Land counsel appearing for the claimant submits that considering the injuries sustained by the claimant, the court had failed to grant a reasonable compensation and it has to be enhanced on all the heads. Next, when counsel appearing for the respondent insurance company submits that no doctor was examined, no evidence is adduced, and the court had rightly considered and granted compensation, and there are no grounds to interfere. This court has perused, having heard the counsels on either side, perused the material on record. Considering the 3 fractures that were sustained by the claimant, under the head of pain and suffering, this court is granting 80,000 towards the medical bills, 16,490. Attendant and transport 11,000. The claimant was the injured is a minor. Considering the loss of income to the parents as this accident has happened in the year 2016, 9,500 into 3, 28,500 towards loss of amenities. Considering the tender age, this court is granting 50,000. Then the future medical expenses 20,000. In the light of the law laid down in Mekala versus so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 2,15,990. Accordingly, the plea is partly allowed, enhancing the compensation from 1,31,490 to 2,15,990. Next slide heading. MFA number 1707 of 2022, arising out of MVC number 792 of 2016. In the earlier case, it's a case of injuries to the minor who is aged about earlier case
7
years.
7 years. The next one. In this case, the court had granted global compensation of an amount of rupees 40,000. It is a case that the claimant had sustained grievous injury to her left forearm from other simple injuries.
Fracture is there, man.
Fracture is there.
Wound certificate says.
And it is found that an open reduction internal fixation to the left forearm
Exhibit P29 wound certificate.
is noticed to have done, but no other evidence is produced. And the medical bills for an amount of rupees 21,484 is placed. And so, and he was there in hospital for 1 day. Considering all this, the court had granted 40,000. Considering the grievous, then counsel for the claimant submits that the compensation needs to be enhanced. Counsel for the respondent submits that the term of compensation is granted. Next part. Considering the fact that there is a grievous injury and though the doctor was not examined, the medical bills, and considering the grievous injury, this court is granting an amount of rupees 70,000 globally.
Earlier matter, serial number 22. Kindly date may be fixed.
Interest
Without
6%.
any
6% interest. Enhanced compensation.
enhanced amount 6%. And what about entire amount 6% or is enhanced?
Here, my lord, 9%.
6%.
9% granted, my lord, we have already
But in that you have not asked for it. In the other case,
asked, my lord.
but it was not reduced. The
At that
entire
time,
amount shall
like-
carry 6% interest. In the earlier matter, without further notice, that remanded matter, which is your case, that is MFA's
22, madam.
6655.
Yes, ma'am.
Without further reference, party shall appear before the court by 13th of October. Within 6 months from 13th of October, the same shall be disposed of. Yes, next.
Serial number 24.
Serial number 21, I have confused the number, madam.
Huh?
Serial number 21, madam. I have updated, but I have confused the number. Some of this year, in the interim order, I have deposited the entire 1,30,000 rupees and reduction of the sum report, madam.
No, what happened to 21? It will come on 26. I have not interfered with the interim order. Interim order is there. It's coming up for dismissal, that's the only thing. It's good that date will be disposed of for you.
Deposited the entire amount as per the sum of court, my lord.
Delete from the caption dismissal, but let it be on the same day.
Interim order.
Interim order earlier granted is extended till then. Yes, next.
Number 24.
Second respondent, my lords, for the appellant, my lords.
Yes.
It's a case of an injury, my lords. The date of accident is at, my lords, 29/3/2017. Lords, I'm on purely on the quantum basis, my lords, for the enhancement of quantum.
Where is
Discussion, my lords.
where is the table?
Table, my lords.
No table.
No table. No table, my lords.
In the synopsis?
Lords, page number 2, my lords. The medical expense has been given and other rates, globally they have awarded, my lords.
Amount claimed.
Amount claimed, my lords, 18 lakhs, my lords.
How much is granted?
Total, my lords, 1,58,000, my lords.
What are the injuries?
Injuries, my lords, there is a fracture, my lords, to the left leg, and operation has also been done, and the rod has been inserted, my lords. My lords would
Pain and
find that
suffering, how much is awarded?
nothing has been awarded, my lords. Globally, they have given, my lords.
We will
Even
split
though-
it.
May I submit, please? The charge sheet against him also, appellant also. The two vehicles are involved in this case. One is case 16A 1007 driven by the petitioner without a dual, without insurance. That is the finding given by we have taken the defense, adduced the evidence. The charge sheet also against him under section 3/181 of the MU Act and also 146/196 of the MU Act. Out of total count, 50% fixed against us, that's the insurance. 25% fixed against him. Another remaining 25% fixed.
Not on that, it's
Only the
only on
quantum.
enhancement of compensation.
Please, ma'am.
So please, pain and suffering will grant 40,000.
My lords, 30% disability, my lords. There is a disability certificate
We will
also.
come to that.
Please, my lords, please.
40,000. How many days he was in hospital?
6 days, my lords. He underwent operation on 30th.
6 days.
6 days.
1,000. Then medical bills,
My lords, medical bills, my lords, as it is, my lords, 83,000 has been granted.
how much?
83,000 has been granted.
83,000.
Please, my lords.
Then, is as per the evidence of the doctor, what
My
is the
lords.
disability?
30%, my lords.
To the limb.
To the limb, my lords.
That's 10% to the whole
Please,
body.
my lords.
Was it considered or not?
No, my
considered?
lords, not been considered.
Where is the evidence listed? That
My
finding we will
lords,
see?
my lords would find at page number 13 of the judgment, my lords.
Hmm.
Para 16, my lords.
Let's
I mean,
read from
para
para
15, my lords, para 15. Petitioner also has relied upon the evidence of his doctor, so-and-so, who has been examined as PW2. In his evidence, he has apprised the fact that he has treated the patient has swelling, tenderness, and the deformity of his leg, right ankle. He has medically examined the petitioner. On clinical examination, petitioner undergone surgery, fixing a screw and a K wire to the fractured portion, and he was then discharged on 3/4.
Where is it discussed? By
My
the
lords,
court?
the next line, my lords. Petitioner still having a persisting pain in the factual area is
No,
having
no, I have seen
30%.
15. Where is the
Exhibit.
consideration of the court?
That has not been considered,
Why?
all my lords.
We'll take 10%.
My lords, the income would be the 11,000, my lords, as per the
One
chart.
minute. Loss of future income. Which year is the accident?
My lords, 2017, my lords. It comes to
10,000.
11,000.
Into 12. What is the multiplier?
Multiplier would be 18, my lords, age 25 years.
Into 10 by 100.
It amounts to 2,37,000, my lords.
It comes to 22 lakh 37,000. How many? Then loss of income during later period.
6 days, my lords. And he is also underwent surgery, my lords. Even the doctor has admitted the same.
4 into 11,000. 44. Then
Pain and suffering, my lords.
pain and suffering is already granted. Loss of income during later period. There's loss of amenities. 30,000.
My lords.
Medical expenses 10,000.
My lords, attending charges, my lords.
That is
because-
already granted 6,000. It's coming to 4,50,600. And what is the contributory negligence?
25%.
Fees
25%.
25.
totally 50%, 25% against him, remaining 25% against the first respondent here in please. There is
The
agenda,
first respondent.
The owner of the offending vehicle.
owner of the vehicle.
Offending vehicle.
So
Remaining
insurance
50% against us.
versus 50%.
Please. Totally 50%, out of 50%, 25% against him, 25% against the agenda first respondent before the lordships, and remaining 50% of us.
You have to pay
And then record, my lords.
2,25,300 you have to pay.
As against earlier paid by the tribunal.
My lords, they have to pay the 75%, my lords. Out of 75, 25 they have to recover from the owner of the vehicle.
Oh, pay and recover.
Pay and
is
recover.
ordered.
No, my lord.
Where is that? Let's see.
Kindly para 18 of the judgment, please, madam.
Yes.
Here, DL, ಇವ್ರಿಗೆ ಇಲ್ಲ sir. There is no DL.
Read from 18.
Para 18 of the judgment, please.
Hmm.
Already discussed and held that the petitioner case contributed his part of the negligence riding the motorcycle so and so number uninsured without having a valid driving license. The rider of the
When
same.
your vehicle itself is uninsured,
Please, my lords.
there will be a pay and recover?
My lords, offending vehicles insurance is there, my lords. Mine is,
And read further.
Read that the
vehicle is-
petitioner
there are two
himself
vehicles.
petitioner himself bear 25%,
That
sum
is
of rupees
clear.
so and so, and first respondent Ajana shall bear the 25% at the so and so. Have entrusted the vehicle being number so and so, Shiv Prasad who died in the accident, please, madam. Unauthorized.
Owner of your vehicle.
owner, mine vehicle, not my lords. The owner of the vehicle is a different, my lords. The person who is riding that
But
person
if you
is
read
died.
it, that's what we understand.
My lords,
It is referring to you and it says about the owner who has given the vehicle to you, who is not having.
my lords, my vehicle is different and the offending vehicle is completely different, my lords.
Please read again.
My lords,
The
first
petitioner
respondent.
himself has to pay 25% of the sum, which comes to rupees 39,000.
Please, my lords.
And also first respondent shall have to bond 25% sum, rupees 39,500, for having trusted his motorcycle bearing number. Who is Shiv Prasad?
That is the rider of the
Rider
offending
of the
vehicle, my lords.
motorcycle number
Unauthorized
KS16X.
rider who found with no will to deal the same under the light of fact that motorcycle bearing registration number was duly within, the instrument shall be liable to pay. As regard, where is the clarity with regard to
50.
no pay and recovery is
And
ordered?
no pay and recovery, my lords. My apologies, my lords. But the thing is that
I have to clarify that now.
Please,
Because when it is insured and he is not having a driving license on that ground,
pay and recover.
you ask the owner to pay, he is a third party, will say you have to pay and recover.
Please. And remaining 75%, please.
25%.
out of 75, 25% they have to pay and recover, my lords.
50% you have to pay, 25% he has to pay, and you have to recover. Then now for initially entire 75% you have to pay.
Out of total compensation, 25% liability against and recover from the owner of the offending vehicle, please.
It comes to, entire amount comes to 3,37,950 minus 2,25,300. It is 1,12,650 is a liability of the owner of the vehicle.
Clean. Out of that remaining 50% to be recovered from the.
Yes. Please come.
50% comes to.
That I
as-
understood you. You will also understand once I dictate the order.
Please.
Agreed with the award passed in MEC number 46 of 2018 dated 13th March 2020, whereby the court has granted an amount of rupees 1,58,000, and in the said amount 25,000 contributory negligence is fixed on the claimant, 25% on the owner of the offending vehicle, 50% on the insurance company. The claimant is before this court questioning the liability as well as that is fixed on the owner, as well as seeking enhancement of the compensation. Land counsel appearing for the claimant submits that when the offending vehicle is insured, and just because the vehicle is given to a person who is not having the driving license, That itself cannot be a ground for the court to fix a liability on the owner of the vehicle when the petitioner is a third party to the insurance policy and the principle of pay and recover applies. When it comes to the compensation, he submits that on all the counts, the compensation that is awarded is not just and reasonable. It is submitted that when the doctor had deposed that he had sustained 30% disability to the whole body, to the limb, the court had not at all considered the disability and not granted the amount under the said head. It is submitted that the compensation needs to be enhanced. Next paragraph. When counsel appearing for the respondent insurance company submits that even on the liability and on the quantum, court had rightly granted the compensation and there are no grounds to interfere. Next, having heard so and so. First, coming to the aspect of compensation, the claimant has sustained one fracture injury. Hence, under the head of pain and suffering, this court is granting 40,000. He was in hospital for 6 days. Under the head of attendant and nourishment, 6,000. Medical bills as it is, that is 83,500. Then coming to the loss of future income, the court ought to have, when the doctor had deposed about 30% disability to the limb, without any discussion, without any basis, court had not considered. Hence, considering the evidence of the doctor, this court is taking the income, taking the disability at 30% to the limb and to the whole body 10%. 11,000, and this accident had happened in the year 2017. Hence, 11,000 into 12 into 18 into 10 by 100 is 2,37,600. Under the head of loss of income during the later period, 4 into 11, 44,000. Loss of amenities, 30,000. In the light of the law laid down in make allowances so and so, legal expenses, 10,000. Altogether, the claimant is entitled for 4 lakh, the compensation, altogether the compensation is 4,50,600. As rightly argued by the land counsel for the claimant, when just because the driver of the offending vehicle is not having the license, the 25% disability liability ought not have been fastened on the owner of the vehicle alone. In the light of the law laid on Saran Singh's case, the principle of pay and recover applies, and the insurance company is liable to pay the entire 75% compensation and recover the 25% compensation from the owner of the vehicle. As far as the liability contributory negligence that is fixed on the claimant is concerned, the court had rightly fixed, and this court do not find any reasons to interfere. Hence, out of 4,50,600, 50% is 2,25,300, and the 25% is 2,25,300, and the 25% is 1,12,650. The compensation, that is 75% of the compensation, is 3,37,950. The insurance company shall pay 3,37,950 and recover 1,12,650 from the owner of the vehicle. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,58,000 to 3,37,950. The enhanced amount shall carry 6% interest.
Great.
Number
The
25.
principle of pay and recover applies. Insurance company shall pay the 25% recovery. Yes. In the operative portion.
I am for the appellant in this matter, my lord.
25.
I am challenging the in first matter, my lord. I am challenging the apportionment fix.
MFA 6022 of 2023, my lord. My lord, kindly respond number 3. Notice may be dispensed with, my lord. Policy.
Take that.
Second, 321 days delay in filing the appeal, my lord. In this case, my lord, 2 appeal is filed, my lord, challenging the quantum.
A memo is for seeking dispensation of notice to third respondent. Memo is taken on record and notice to third respondent is dispensed with. IA number 1 of 23. You are for the claimant.
Yes.
IA number 1 of 23 is filed to condone the delay of 321 days for the reason stated.
Interest may be.
Delay is condoned on the condition that will not be entitled for the interest. Yes. Who is the appellant in the first appeal? Owner of the vehicle.
No, my lord.
Why? In the first matter, my lord, I have.
I think you better come. It's a punishment for the court to hear the advocate on final hearings from the online.
Sorry, my lord.
two appeal is filed, my lord. One is the wife of the deceased, second one is the parents of the deceased, my lord.
Oh, it's
My-
on the apportionment.
Apportionment.
How it is apportioned?
My lord, parents, my lord, 25% each, my lord.
That is
Wife-
50%.
Wife is 50%, my lord.
How can it be?
My lord,
Who appears for the wife?
I am for the, I appear for the wife, my lord, in first
What is
matter,
the age
my
of
lord.
the wife?
Age of the wife, my
30,
lord.
31 years, my lord, 31 years.
What is that? 31.
31.
And what
Yes,
is the
my lord.
for the parents?
Parents, my lord,
Parents are 60, 68 and 72, 68 and 72, my lord. And
About the-
admittedly, my lord, admittedly in your cross-examination, my lord, see, they are residing with other 3 children, my lord. It is admitted fact in our
We'll make it
cross-examination.
70-30.
Yes,
We'll
my
make it 70-30.
each 30.
Why for the old,
Obliged, obliged.
old age parents
Sorry,
at
sorry, my lord.
78?
After the marriage, my lord, wife is separate living. They have no children, my lord. The age-old person is the parents.
No,
my
you
lord.
have other children also. Parents
Yes,
have other
it is
children also.
admitted fact.
Also, they are separately living, my lord.
No, in the
Separately
cross-examination, it is elicited that you are living with them.
Yes, my lord. Separately living, my lord. The
Not
parents of
separately living, you are living with the other children.
No, 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 no. He is
What are you saying?
admitted there, my lord. That's admitted, my lord. Parents are
In,
admitted.
in
They-
RW on cross-examination, my lord. They are both are residing are 3 children.
Yes, Pradeep, in generally in these cases, how it is
On quantum, my lord, 9,000 has been taken by the tribunal. 14,000 has to be taken.
No, that we will take apportionment.
Enhancement 60,
Apportionment.
60, 40.
Already.
Other matter I have done,
That's
so
fine.
60-40.
60, 40, 40.
Same ratio, my lord.
Same.
Same ratio,
My lord, I don't, I am, I don't have issues, my lord. That's why I am not able to partition the ancestral property also, my lord.
Similar set
That's
of
why.
No, yesterday, in another matter, I've granted 60-40. That's what they're saying.
Yes, my lord. 60 parties are.
Yesterday, I passed one order.
More than 5 acres ancestral
that,
property is there, my lord.
that you can proceed.
case also
Let's do the calculation.
Madam?
Calculation again. Phantom.
Quantum,
70,
14,000 has to be
70,
taken.
30,
What is the age of the
70,
deceased?
31 years, my lord.
31 years.
What is the income? Which year is the accident?
Accident, my lord, 2019.
2019.
14,000.
14,000. Plus 40% future prospect.
Yes, my lord.
5,600.
All without Pradeep is working like a calculator.
1/3.
One-third deduction.
Into
1/3
40,
deduction. 1/3 deduction,
No,
madam.
it's coming to 5,600.
600. 5,600.
19,600.
How much has to be deducted?
1/3, my lord.
One-third.
Only 3.
Yes. 25,88,634. Loss of dependency.
It's coming to
13,600.
6533.
25 lakh.
No, the difficulty for me is to dictate. I have to look at, I have to write it on each this thing. 13,067 into 12 into
16, my lord.
16.
25 lakhs.
It's coming to 25 lakh
88,000.
08,864.
864.
Then 44 into 3. How much it is? 1,24,000.
Yes. 1,20,000.
24.
Month.
44 into 3, my lord. 132.
Huh?
132. 132.
Next 36,000 and 10,000. Plus
10,000. 10,000.
plus
My humble request, my lord, 70, 30 may be fixed.
it is coming to 26 lakhs 86,864 into 60 divided by 100 is 16 lakhs 121. Ten thousand 118.
86, 86, 86, 860.
Then it is 10,74,000. 745 to the parents, 16,12,118 to the wife. Please come. Agreed with the award passed in MEC number 1822 of 2019 dated 6th July 2022, whereby the court had granted compensation of 16,82,800. Both the wife and the parents are before this court questioning the quantum as well as apportionment of the compensation. The MFA number 6538 of 2022 is filed by the parents and of the deceased, and MFA number 6022 of 2023 is filed by the wife. No, by the parents. First is by the wife.
Yes.
MFA 6538 is by the wife,
Yes.
and MFA 6022 of 2023 is by the parents. The deceased was aged 31 years and he died in the accident that took place on 15/5/2019. The court had taken the income at 9,000 and the accident had taken place in the year 2019 and granted the compensation as per the table given below. Look at the table at paragraph number 28. And further, it is held that what is the apportionment?
50-50.
And
50-50.
further, apportion the compensation.
50 to the wife and
50%, 50% on both the wife and the parents. Learned counsel appearing for the claimant, both the claimants, that is the wife and the parents, submits that the compensation that is awarded by the tribunal is not just and reasonable. The court ought to have taken the income at 14,000 and future prospects at 40%, as he is aged about 31 years. When it comes to the apportionment, it is stated that the wife, at least the 70% of the compensation ought to have been, land counsel for the wife submits that 70% of the compensation ought to have been granted to the wife. And as the parents are staying along with the other children, land counsel appearing for the parents submits that though they have the other children, but they're staying separately, and the court ought to have granted 60% to the parents. Next, land counsel appearing for the insurance company submits that the court had rightly granted the compensation. There are no grounds to interfere. Next, first coming to the aspect of compensation, the accident had taken place in the year 2019. As per the notional income, this court is taking 14,000, and as he is aged about 31 years, 40% future prospects would come to 5,600. That is 19,600. As there are three claimants, 1/3 has to be deducted towards the personal expenses. 1/3 is 6,533. Then the contribution to the family is 13,067 into 12 into 16. Under the head of loss of dependency, it would come to 25,08,864. Towards the loss of consortium, 1,32,000, 44 into 3. Funeral expenses 36,000. And in the light of the law laid down in Mekala versus so and so, 10,000. Altogether, the claimants are entitled for an amount of rupees 26,86,864. Considering as far as the apportionment is concerned, in the considered opinion of this court, by granting 60% to the wife and 40% to the parents, it would be the interest of both the parties, and it would be balancing the interest of the parties. Hence, parents are entitled for 40%, wife is entitled for 60%. Accordingly, the MFA, both the MFAs are disposed of, and not both them, because compensation is enough. Both the partly allowed, both the MFAs are partly allowed. The amount of compensation is enhanced from 16,82,800 to 26,86,864. In that, the wife, that is the petitioner in MFA number 6538 of 2022 is entitled for an amount of rupees 16,12,118, and the parents, that is in MFA number 6022 of 2023, are entitled for 10,74,745. According, and the enhanced amount shall carry 6% interest. Yes.
Lord, with enhanced amount kindly- enhanced amount kindly release the.
That will be there. Yes.
Your Lordship's kind permission. The serial number 23, my lords, just now disposed of. Was head up in another court. Your Lordship, the connected matter 2258 of 21. Your Lordship kindly direct the office to show my name for respondent number 4, Reliance General, HC Beds.
Mr. So-and-so, you will file the wakalat in 1 week.
I will file.
You
In
filed
connected
or
matter,
yet
I
to
have already
file?
filed. Within 1 week you file.
Yes, ma'am. In 23, Mr. So-and-so, who is representing the insurance company, shall file the wakalat within 1 week. And the his name shall be reflected for which respondent? R4?
R4 respondent.
R4, Reliance General Insurance. Yes. Next.
Cell number 26, Mukkanappa SB.
And for the petitioner in the first matter, my lord,
Yeah,
the
right.
second matter, my lord, I'm for the respondent. In this matter, my lord, I filed a
There is no insurance. Oh, it's RPFC. Yes.
RPFC.
Both are
In this
in a-
matter, my lord, I filed a wakalat, my lord, regarding in respect of respondent, my lord, in the second matter. I gave it next week, today accept that.
You?
Respondent.
No, I understand. You're ready for argument or not?
No, next week.
Lord, it was given 3 times and he has
Lord,
stayed
yesterday,
on
I-
all 3 occasions. I will not say anything more.
so many
It's a
times. that the-
2024 matter. Your matter is, no, 1 minute. Your matter is also 2024 matter. Now you have your order copy,
Yes.
isn't it?
Yes.
So you can look at that and you can argue.
My lord, so many times this honorable court has directed to the served the copy to the petitioner. My lord, yesterday they have served the copy, my lord.
What to do? This procedure is a
But-
routine procedure. It
My
has
lord,
become
yesterday-
and all these.
Copy I had given 3
Neither
times.
here nor there. No, we are only looking at the
Yes.
RPFC. Nobody, we cannot look into any other except the impugned order. But still, objections, even for people are coming up saying that vacate filed also, again, they want papers on that.
My lord, next week, any date, my lord, I am ready to.
Next week, the court is not ready because there are so many matters next week.
May I
This
make
is
one
matter
submission?
after vacation.
12 lakh is due by way of maintenance, at least state,
They have a
subject to
stay in their
deposit.
matter.
No.
Do they have a stay?
They have no stay.
Then file a execution petition.
No, the
Yes.
execution is
I'll
pending,
record- I'll-
but in this 12 lakh is still due towards education expenses. This is the daughter's.
Oh, I say, against that order, he has filed a RPS.
Yes.
Is there any stay by this court?
No, I have also sought for the same. I am also a petitioner in the connected matter.
If he is not paying, if in his petition there is no stay,
True.
you can file execution petition.
No, I wanted a conditional stay so that at least it deposits in the execution.
No, in 2024, we will not grant any stay.
I leave it to the court.
Yes, this is matter after vacation.
Cell number 27,
Yes, who appears?
Appellant's insurance plan quantum only, please.
Mm.
Petitioner is aged about 23 years, please.
Yes.
He is by profession by barber.
Case of death or injury.
Injury, please. Injury.
Please come to the table.
Judgment page number 14, please, ma'am.
Mm. What are the injuries?
2 fractures, please, not. One is right femur and a left tibia.
Well,
Not discussed in the judgment. I have got the wound certificate.
So 50,000 as it is. But then,
Regarding
how many days he was in hospital?
6 months, madam. Judgment ಎಲ್ಲ ಹೇಳಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ. How many days inpatient ಕೇಳ್ತಾರೆ ಸರ್. ರೆಸ್ಟ್ ಅಲ್ಲ ಹೇಳ್ತಾರೆ.
Inpatient. Para 2 ನಲ್ಲಿ in the judgment, para 2 last line. For 6 months as an inpatient.
Then it is 6 months, it has to be 60,000. Another 10,000 has to be enhanced.
Please. My lord,
my humble submission, kindly.
Unfortunately, my lord, there is no appeal filed for enhancement.
Anyhow, when we are doing it, we'll do it.
We can make.
See?
My
Court has
questioning
got
only
that.
percentage of disability, please.
That's what. Where has to be enhanced, we'll enhance. Where has to be, it has to be reduced, we'll reduce.
Please, please.
Then,
Doctor deposits.
No, 1 minute. Medical expenses as it is.
As it is, please.
1 minute. Let me write it down. 2,03,518.
The actuals, please.
Then loss of amenities. What is the disability according to the doctor?
His doctor deposed 56% limb disability, not assessed whole body disability.
We will take it 1/3 if it is.
No,
why
my
should
lord.
we-
Since one submission, please. The fracture of fibula and tibia, not 56% higher set. Please. Maybe consider limb disability 30%, whole body 10%.
It
My
comes
humble
to-
request.
My lord, he has
Report had taken
cross-examined
how
the
much?
doctor also.
Not at all taken, please. Or he not at all discussed, simply directly granted the 6,35,440.
Oh. For calculating that,
30% considered by the learned judge, please.
limb disability is 56.
56 ಅಂತ ಹೇಳ್ತಾರೆ.
1 minute.
ಅಲ್ಲ, before that, please, my lord.
1 divided by 3 is 18%.
18%, before that, please, one submission.
Hmm.
He suffered only fracture, suffered two fractures, one is femur and tibia. Kindly consider the limb disability 30%, whole body 10%. My humble request, please.
We will make it 15%.
It's the higher side, please.
We will make 15%. Via media. So which year is the accident?
2019.
Huh?
2019.
No, 1 minute.
14,000, please. One another submission, please, ma'am.
This loss of amenities on the higher side, we'll make it 30,000.
Please, ma'am.
So no loss of future income.
14,000
Here
into
is the accident?
14.
14.
Sorry, 19, please. 14,000 income, please.
14,000. So 14,000.
That is also notional income has been taken. Since the claimant has not produced the
14,000 into 12 into.
Oh no, 23 is 18 multiplier.
18 into
18.
10 into 15 by 100. It is coming to 4,53,600. Then where is the loss of income during the laid-up period?
that head is not calculated.
So loss of income during laid-up period.
For these two fractions, may consider for 4 months, please.
No, he was there in hospital for 6
For
months.
6 months.
He's safe, please, Manad.
No, but
There is any
nothing-
documentary
nothing-
evidence or discharge summary like
To
this.
14.
Discharge summary is produced.
84,000.
Please.
Future medical expenses. He's on the higher side.
It is also
50,000.
to be reduced, please.
Let us make it 30,000.
Please.
It's coming to 9,21,118 against 10,38,558.
Madam, as far as the future earning capacity is concerned, my lord, para 16, he has, the trial court has delivered, in detail has.
Granted.
Hello,
Granted.
no, my lord. Future
No,
prospect is
that
not
has been
entitled, please.
reduced, my lord. That has been reduced by this honorable court.
Because
Now, my lord,
disabilities-
if I may be permitted to read para 16 of the judgment, in which, my lord, the trial court has in detail,
No, we are on the point of disability.
Please,
That
ma'am.
disability, I have not reduced anything. The point of disability is reduced. That is given. No,
my lord, even the disability, my lord, has been given by the doctor and he has been
If you want-
cross-examined.
If you want, I will set aside this order. That cannot be. For a disability of 56%,
My lord.
the whole body disability cannot be 36%. It has to be 1/3.
If that is calculated, my lord, it comes to 18%.
But I'm not, because that the disability, the injury for which you have, generally the courts are taking 10%. Yesterday also I passed one order. Already this court has considered 15, that's why.
Please.
Yes.
I'll leave it.
Agreed with that. In
One submission-
fact,
I'm
no,
I'm only on the point, my lord.
No, there is no appeal of yours.
Please,
Still.
please, I concede to that, my
No,
lord.
pain and suffering, I made it 60,000.
Please.
Attendant nourishment, I made it 60,000. Otherwise, there would have been another less amount. Agreed with the word.
And the future prospects to be set aside, please.
I have not granted anything. Future prospects for that disability of 15%.
That does
it
not
can't
arise,
be.
please.
So I have not granted. Agreed by the award passed in embassy number 480 of 2021, dated 7th October 2022, whereby the tribunal had granted compensation of an amount of rupees 10,38,550. The claimant is before the insurance company is before this court questioning the quantum. The tribunal had granted the compensation as per the table given below at page 16. Land counsel appearing for the claimant submits that the injuries that are sustained by the claimant are, where is that?
Not discussed in the judgment case about injury. In the wound survey, it is mentioned.
What it says?
My lord?
My lord, in the second paragraph, it is mentioned, my lord.
Yenant.
High speed due to which the petitioner has fell down and sustained fracture and injury to both legs and other parts of the
Injury
body.
to both legs and other parts of the body.
Please, ma'am.
The doctor had opined that
56% lower limb, please.
1 minute. The doctor had opined that a disability is 56%, and the court had taken the disability
30%.
30% and granted and taken the income at
14,000.
14,000
ಹೌದು,
and
same
granted
income tax.
40% future prospects. Land counsel submits that the court, the doctor had not deposed what is the whole limb disability, what is the whole body disability. His the fracture is to the femur.
Femur and fibula.
Femur and fibula, and as
Disability certificate is at exhibit P195.
the femur and fibula, and for the injuries to femur and fibula, the disability cannot be at 56%. It is submitted that the court, without any basis, even the percentage of disability that is given on the higher side, generally 56%. Generally the limb disability, 1/3 of the limb disability is a whole body disability, and the court without any basis had taken 30% as a disability. It is submitted that the amount needs to be reduced. Next para. Land counsel appearing with the respondent claimant submits that the doctor was examined. Doctor has placed before the court the disability certificate, and the court had rightly taken, and there are no grounds to interfere. Next para. It is submitted that in fact the claimant has not filed appeal, but on other grounds the court had not granted a reason, and not for under the head of loss of future income, no amount is granted. Not a loss of income during the later period, the court has not granted any amount. It is submitted that the amount that is awarded by the tribunal is reasonable on other counts, and no interference is called for. Next, having heard so and so, this court has perused the order and the material available on record. As rightly argued with the land counsel for the insurance company, the tribunal had failed to had taken the disability on a higher side, and the evidence of the doctor as is also appears to be the percentage of disability on the higher side, considering the fact that it is an injury to the fibula and femur. In these circumstances, this court is inclined to take 15% as a disability, though there is no appeal of the claimant, as this court is interfering with the compensation that is awarded. Wherever the compensation that is not awarded, this court is inclined to increase the said amount in the facts and circumstances of the case. Under the head of pain and suffering, considering the two fracture injuries, this court is granting 60,000. Towards attendant nourishment, as he was there in 6 months, this court is granting 60,000. Medical expenses, 2,03,508 as it is. Loss of amenities, this court is reducing it from 50 to 30,000 for the disability of 15%. Loss of future income, 14,000 into 12 into 18 into 15 by 100 is 4,53,600. Loss of income during the later period, 6 into 14,000 is 84,000. Future medical expenses, the court had granted 50,000. This court is reducing the same to 30,000, and it comes to 9,21,118. Accordingly, the appeal of the insurance company is allowed, partly allowed, by reducing the compensation from 10,38,558 to 9,21,118. The amount in deposit shall be forthwith transferred. If any excess amount is deposited, the appellant insurance company is at liberty to withdraw. Yes, done. Disposed of. Just leave it there. Yes. WP. No. Second is RPFC. Monday it will be MFA. Freedom General Insurance thereafter. He has given any other list or the same list? Only 5-6 months. Add them to the list. Yes. ಅದೇ ಬಿಡ್ಸು ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ಕೊಡ್ತೀನಿ ಕೊಟ್ಟೆ ದಾರ ಕೊಡಿ
ಕೊಡ್ತೀನಿ.